Another one, students. I recall being in the classroom and Rihanna came up and said, oh yeah, Rihanna's black. I said, why are you saying Rihanna's black? Well, what do you mean, Mr. Bay? You know, yeah, you're black. All right. You're saying that I'm black. Why? Because of what you look like. What do you mean? So I said, all right. Sammy Sosa, as dark as I am, or was as dark. Sammy Sosa, my complexion. Then we have a Mexican, my complexion. A Dominican, my complexion. So what would you call them? Dominican, Mexican. Yeah, Mr. Bay. Hold on. I'm trying to understand you. You said that I'm black because of what I look like. Based on what you said, it doesn't match. Well, why you call Sammy Sosa Cuban? Why did you call Sammy Sosa black? Why did you call me black and not Sammy Sosa black?
Yes.
Why do you refer to Sammy Sosa as Cuban, but you refer to me as black? We're the same complexion. Mister, I don't get it, mister. I don't get it. All right.
Are you a deep diver for knowledge? Do you like to explore historical content of language, grammar, and law? Well, Academy of Providence is a unique certificate-based virtual learning institution with an aim to draw out a person's innate talents and abilities by imparting the knowledge of languages, epistemology, scientific reasoning, jurisprudence, positive law, history, literature, rhetoric, and more. The channels through which those abilities would flourish and serve the communities as well as the nation. Our goal is to help you dive deep into critical analysis, thinking and reasoning of these areas towards becoming philosophers or humanity of learning or humanity of science, which creates society's great artists, painters, musicians, jurists, doctors, astronomers, biologists, engineers, cartographers, surveyors, photographers, chemists, herbalists, entrepreneurs, computer scientists, teachers, politicians, and statesmen. So, if you are determined and willing to go beyond, Academy of Providence is the perfect place for you. For more information, visit our website, www.academyofprovidence.org.
All right, so finishing up this point. So why use nationality, Mr. Bay? It's not on the forms. Why nationality? Race. What are you talking about? Nationality is not the real world. That's why. That's why she said nationality is not the real world. All right, so this is where Morocco comes in. Morocco, recovering our lost sovereignty. We have to claim our people. We have that is a massive violation of international law. That's denationalization on a massive scale for over a 400-year period. But a nation has to address that. As individuals, right? Meaning, as individual Moors, you will not be successful. Morocco has to do it, not the Moors. Morocco, all right. Do they say the Chinese or China? France, Germany, Nigeria, England, the Netherlands. These are so that the sovereignty is already vested in Morocco. It doesn't have to be done. It doesn't have to be done again. We're not entering, we're not a new state. It's an old state. So it doesn't have to be vesting sovereignty into creating a state. It's already, the sovereignty's already been created. There's already obligations. There's pre-existing treaties. In 1952, France, in the International Court of Justice, France and the United States, France used 3 types of treaties to adjudicate the case, and won the case based on using those Moorish treaties. 3 types of Moorish treaties. So you have the first type of treaties, the bilateral treaties between Morocco and 10 European powers between 1631 to 1892. The second type of treaties, or the treaties between, is the Act of Algiers, 1906, and the Act to Protect Morocco, 1880. The third type of treaty is the Fez Treaty, 1912. I'm going to finish this up here with this is answering Tamara's question. In 1968, Ceylon, Ceylon, the representatives of Ceylon argued against what the United Nations had had classified Ceylon as a new state. The representative went in front of the United Nations General Assembly of the International Law Commission, October 1968, and argued against that. He pointed to the 19th century, 1800s, that the Ceylon had extensive diplomatic relations with nations. So Morocco is not a new state. That's not a new sovereignty. It's a recovery of sovereignty, reversion to sovereignty, not a new state. All right, so I just wanted to bring that home.
Yes, appreciate it. Yes, I'm going to read the last dealing with fiduciaries, determination of entities. A terminating entity, such as a corporation, partnership, trust. Now, you are considered as a corporation or trust. Your mother gave you the name. They made a corporation, and they made a trust. Only has legal capacity to establish a fiduciary relationship while it is in existence. Now, let me break this down to you. When you come to knowledge of your consanguinity, and you form your government structure based on the sovereignty already existing under Morocco, you claim to be a state or a tribe of descent kinsmanship heirs that already existed and had possession rights before the occupying sovereigns got here. You have a right now to change the fiduciary relationship into your government or your trust, because your trust can take it over, which is the living trust of the national, with a cultural identity and a consanguinity and a political status connected to state. Once that happens, the government becomes the protector. Establishing a fiduciary relationship prior to the termination of the entity allows the fiduciary to represent the entity on all tax matters after it is terminated. Let me explain what it means. When you terminate the United States status as trustee, you have to go to the Social Security Administration to do that with a trust indenture. Once the United States, because the president appoints 7 to 6 trustees over the Social Security Fund, which is the old Survivor Pension Benefit Fund. That's an insurance fund. They run the whole world. All the nations invest in that. Their money system do that. Their industry, they agriculture, monetize. They're monetizing the commodities, the sureties. And the bank that holds the account is the World Bank for nations, governments. In the United States, they formed the Federal Reserve Bank, 12 districts. All the states have become banks and signed up under the Roosevelt, under the President New Deal. So they gave up their sovereignty when they did that. They don't have no sovereignty anyway, because they lost that when General Lee ceded. So they lost his sovereignty anyway when he surrendered. He didn't enter a peace treaty. He surrendered to the District of Columbia. That's the new government. So I'm going to get back to this. When you take responsibility of your affairs and rise to the conscience of consanguinity and cultural identity, you come out of the status of being dead. And you come now back under nationality, protected under the laws of your culture. And anything that that nation established through treaty, through constitution, gives you a right. You got a right now to inherit the territorial jurisdiction. That means personal rights, private rights that already existed that are yours before the occupying sovereigns got here under conquest. That's very important. That's only can be raised as a government, because the government, the Moorish government, Moroccan government, becomes your protector. What do you mean, Shem? They represent you in the world court. They ratify the conventions and international agreements. When there's a dispute, the consul or ambassador speaks and defends the integrity of the Moorish government. No individual group can do that. Okay, Abdullah, you can go to the next one.
Yes. Thank you, Shem. Thank you. Great job with that.
Thank you.
Thought-provoking question. What is the ruling authority for the United States? A, United States Constitution. B, the definitive peace treaty between Great Britain and the United States of 1783, also known as the Treaty of Paris of 1783. So what is the ruling, Shem, what is the ruling authority for the United States?
B.
All right, you want to elaborate?
Well, B is the ruling authority, the Versailles Treaty of Peace, that France entered to a peace term and allowed them to exist in the colony territory as a franchise. Now, United States make a claim that they was independent in 1776. Now, if the United States is independent in 1776, there was no United States. It was the colonies, the 13 colonies. So in 1776, there was no United States under Articles of Confederacy. There was no United States of North America in the colony territory. There were the 13 colonies. So the 13 colonies are owned and controlled by the crown and the lords and the freeholders. So to make a claim that the United States that exists under the Jubilee is the same United States that was independent under the Declaration of Independence of 1776, there's no way you can prove that. No document can prove that.
Right. Let me add to this. All right. In the Treaty of Paris between the United States and Great Britain, the boundaries of the 13 British colonies on Moorish soil is outlined in there, also, as well as, so what allows the 13 franchise states, not the 13 colonies, the 13 franchise states.
Yes, right.
To this day, January 14, 2022, is the Treaty of Paris and not the United States Constitution. You cannot show me in the United States Constitution any boundary markers for the 13 colonies. You cannot show me the language. Great Britain allowed the boundary markers, the agreement is in the Treaty of Paris, not in the United States Constitution. So to say that the United States Constitution is the ruling authority for them in the 13 colonies, the ruling authority in the Northwest Territory. No, it's the Treaty of Paris. They have to go back to the Treaty of Paris. If there is, in fact, there was a boundary dispute between Great Britain and the United States. Great Britain, that the boundary disputes, which also led to the Jay Treaty between Great Britain and the United States in 1795. So they went to where? The Treaty of Paris. To even iron out any boundary disputes.
That's right.
To know where the boundary markers are, who has the boundary markers. It's in the Treaty of Paris. It's not in the United States Constitution. It's not the ruling authority. So, go ahead, y'all.
Question, Abdullah. So, Abdullah, it's safe to say that the treaty survey, the Crown was an authority to make the survey that distribute and delegate authority to the United States where it should have its political jurisdiction.
All right, let's go back. Now, the survey for the Northwest Territory, the survey for Canada was done by France. It was done by France.
Yes.
From 1656 up until 1763, the Treaty of Paris between France and Great Britain that ended the 7-year Pontiac War. So it was France that surveyed.
Yes.
Not Great Britain. France.
Yes.
France ceded. The word cede is in the Treaty of Paris of 1763. The cede, not it has relinquish and cede, but the word cede is not in the Treaty of Paris between Great Britain and the United States of 1783. Just look at these treaties. So why is the word cede? France cedes to Great Britain. Why is that in the 1763 Treaty of Paris? But why does it read Great Britain cedes to the United States? It reads Great Britain relinquish. The words are not the same because both relinquish and cede are both in the 1763 Treaty of Paris between France and Great Britain.
Yes.
Both words are in there. So I gotta just throw facts. So the boundary markers is in the Treaty of Paris of 1763. That was first, all right, because it was already surveyed by France. France just ceded. They ceded the territory, large portion of Moorish territory, which is now, that's Canada. That's Canada. That's the Northwest Territory. And as a result, what allowed to this very day, the Treaty of Paris of 1783, not the United States Constitution. The United States Constitution does not give the United States any authority to be in the Northwest Territory. The United States Constitution doesn't give the United States any authority to be in the 13 colonies on Moorish soil. It is the Treaty of Paris.
Yes.
That's so. We want to make it very clear that the Treaty of Paris is the ruling authority for the United States.
Yes.
This is a 3-part series. This is a 3-part series. So tune in next month and also May and March. All right, because we got a lot more. All right, this is a 3-part series. So there's only so much we're going to present today. All right, we have a lot more to present.
Question.
All right, question.
Yes, we have an online thought-provoking question. Well, statement for clarification and to rule out any misconceptions. The treaty you talk about all the time is worthless. It was with the government of the Moroccan Empire, which ceased to exist in 1956. Therefore, the treaty ended in 1956. So you guys need to get a brain. Can you clear up that conception?
All right, don't hold it, Shem.
You guys that, go ahead.
Now, that means I have to go into what we're going to talk about in week 3. I mean, class part 3, because we have treaties.
That's
We
right.
have United States Supreme Court cases.
That's right.
Society versus New Haven, Ware versus Hilton. You know, so we have these Supreme Court cases that speaks otherwise. I mean, all right. That's what was stated is not a fact. The Supreme Court cases are the facts. The jurists, the Supreme Court justices are not making that. You're talking about violating the Treaty of Paris, that the Supreme Court is going to make a ruling where the world is watching. The world is watching. Because if the Supreme Court errs on that, then the rest of the world with whom the United States has treaties are going to do what? Oh, shucks. They're not honoring treaties. They're not honoring the law of nations.
That's right. That's right.
Oh, shucks.
It's an act of war.
This is major.
That's right.
This is why the Supreme Court justices must be educated. They can't just arbitrarily make these. I appreciate the comment. Thank you. I appreciate the comment. We'll go into in March the cases. So Society versus New Haven, Ware versus Hilton. You have a host of other Supreme Court cases where it dealt with the confiscation, because in the Treaty of Paris of 1783, the loyalists or Tories, those who remain loyal with Great Britain and had to maintain allegiance, their right to recover land that had been confiscated. All of the franchise states in 1781 had enacted the Confiscation Act. Alexander Hamilton dealt with 60 cases of wealthy Tories dealing with the Confiscation Act, which is a violation of the Treaty of Paris. Also in the Treaty of Paris, that the Tories were able to allow to collect on debt before the war. In the 1823 case, Society versus New Haven, the Revolutionary War does not extinguish any pre-Revolutionary War debt or obligation. That's the Supreme Court, not Abdullah Bey. That's the United States Supreme Court, 1823, Society versus New Haven. That's the Society of the Propagated Faith and versus New Haven.
Yes.
Yeah, we got to present facts. I thank you. Please bring the comments. Please bring the questions. Please, yes. Please. I love it.
I'm not going to go into the. Okay.
Yeah, keep on going.
Yes. Go ahead, Abdullah.
All right. Who are we, the people of the United States Constitution, in the preamble? We have we have a government by the people, a government of the people, a government for the people. Want to break that down, Shem?
Yes, a government by the people. The people is the crown, the lords, and the freeholders. The ones who receive the charters, also the ones that the charter had given grants of land, who became patents. They become the freeholders. A government by the people is the crown and her privacy council, and a government of the people, mean of the lords, esquires, and a government for the people, that's the crown and her successors and heirs. That's it. It ain't the common people that was allowed to vote. No, the Constitution wasn't by them. They're not the people. Because the same people that they boast in, John Adams, Thomas Jefferson, George, they're all esquires. So they're holding a ranking title under the crown, the Great Britain, the British crown. So you calling the subjects of the crown your founding fathers. See, you don't catch what's going on here. You better catch on what you're saying. You're not even recognizing what's going on here. You're calling the esquires, the subjects of the crown that works for the lords and freeholders, your founding fathers. and you want to argue about don't hire an esquire, don't contract with an esquire. Well, that's the only reason why you got rights to vote, because of the esquire. That's who drafted the instrument, the esquire. He is the Sixth Amendment counsel under common law. There's no other officer or agent under the British Crown and the colony territory that represented the Crown, the lords, the freeholders, all the planners, was the esquires. Go back and read, look, go back and look at the documents. There is no common people, subjects that represented the Crown, that even represented themselves on a petition to the lords or the freeholders. So when you teach United States history or Moorish Americans or Moors that's unconscious, listen to me. You cannot say that the United States Constitution is the law to protect you, because the drafters of the instrument are British agents, esquires, and subjects. So you can't be partial with them and equal with them. It's impossible. You have a different status. Even saying in the Constitution, no title of nobility. That's indigenous. That's indigenous woman. That's the one indigenous. Native Moors of the land. So we have to be careful. If you're a Moor, you got consanguinity. If you're unconscious, you don't know this concept. You have to go back and read and look at there's a vested and uninvested. Vested means it's inherent. Invested means you delegated authority. The people is delegated authority to vote. They were given permission in the new charter to vote. In the old colony charters, they couldn't vote. They couldn't even make any decisions. They had absolutely no control over their dynasty, over their direction in the British Empire. But as being a subject, paying taxes, fees on their goods, income. You have to realize what started the Revolutionary War is in the British ranks. There became a scam to overthrow the lords in the colony territory in the crown by certain British ranking officers, yes, and political power. They used the people as the pawns to fight the war, to try to overthrow and take control of the British colony because of the revenue. See, nobody talks about this. I can read this. I can go back and find this.
Keep on.
So what we have to understand, that you cannot take a people, descent, kinsmanship of immigrants that came off a boat that's not native to the land, and take a document that's drafted up by a foreign subject to a foreign crown and say that you get your benefits and your rights from that, your protection. You just nationalize yourself. You think you would add to that?
Well, you broke it down, Shem. We're going to continue. We'll continue. Yes. Good job. Who are the drafters of the United States Constitution? Have esquires are given delegated authority by the crown to draft documents, and you actually went over that. Just reiterate that point, Shem.
And under the British, French, under Spanish, French, Portuguese, Irish, even the Catholic, Rome, the Roman Empire, and under the Greece, going all the way back to the ancient empires, they wasn't called esquires then. It was called juris consultus. The modern name esquire came later on, that represented the king and doing documents and draft and conducting certain commercial affairs with other nations. And the esquires are the gentlemen ranking below a knight. So the esquire was educated and put in position to go out under the 16th century opinionated ideology, methodology of the colleges of Europe. Their job was to go out, and when they write the treaties and when they enter into agreements with the native people, their job was to identify the native people in the document as not being a native, but being of what? Being someone under title of racism, therefore they become deceased.